just in the last 6 months, they've had to be contacted about a sentence mod application he filed, a motion to correct an illegal sentence, which is still pending here, several habeas matters that he's been pending here, and a variety of other motions that Mr. Austin has filed. In the time that he has been incarcerated, what I notice as a pattern is Mr. Austin, between DOC, perhaps the Board of Parole, perhaps his parole officers, anybody interviews him, judges, attorneys. I do not know Attorney Wilson, but I feel bad for her because I predict at some point she's going to have a habeas against her because he's filed it against every single lawyer who has ever represented him.
We are about to watch the commutation hearing of a man who has been locked up for 24 years for a crime that he still claims he did not commit. And it was committed when he was 16 years old. What's also unique is that he has over 236 write-ups, or as they call it, tickets, which might be a record from what we have seen. At the end, we'll go through the court documents and make a decision whether we think he's innocent or guilty. But with that, let's jump in.
Good morning, Mr. Austin.
Good morning.
My name is Parole Officer Logan. Today is Friday, March 22nd, 2024, and this is a Public Act 1584 hearing of the Connecticut Board of Pardons and Paroles. Mr. Austin, for the record, the state of Connecticut passed and made effective October 1st, 2015, Public Act 1584, an act concerning lengthy sentences for crimes committed by a child or youth, and the sentencing of a child or youth convicted of certain felony offenses. You fall under this act, and basically this states that you were under the age of 18 and that the board shall give great weight to the diminished culpabilities of juveniles as compared to adults, the hallmark features of youth, and any subsequent growth and maturity that you displayed while we are reviewing you for suitability today. The following board members are present this morning, and by stating their names on the record, certify they have reviewed all statutorily required documents in preparation of this hearing.
Good morning, sir. I'm Jennifer Zaccanini. Good morning. I'm Channel Member Page. Deborah Smith Palmieri.
Also in attendance this morning is Attorney Wilson. Can you please state your name, juris number, and business address?
Yes, good morning. My name is Julia Wilson. My juris number is 445127. My business address is 73 Main Street, Middletown, Connecticut, 06457.
Thank you. Also in attendance is Also in attendance is the state's attorney. Please state your name, juris number, and business address.
Good morning to the board. John Doyle, State's Attorney for the Judicial District of New Haven. Juris number 415543. Address 235 Church Street, New Haven, Connecticut. Thank you.
Thank you, Attorney Doyle. Mr. Austin, please state your name and inmate number for the record.
Ira Austin, 275666.
This is a public hearing in accordance with Chapter 14, Freedom of Information Act, Connecticut General Statute 1200, which applies to this procedure. Mr. Austin, if you have any questions concerning the above, please bring your questions to the attention of the panel at this time.
I have no questions.
Again, this is a public hearing. Do you have any questions, and are you willing to proceed at this time?
Yes.
This 1584 hearing is being conducted in consideration of the parole application for Ira Austin, who is serving 35 years for manslaughter first with a firearm, 3 years concurrent for carrying a pistol without a permit, 1 year concurrent for use of motor vehicle without a permit or permission, 2 years concurrent for larceny third, 2 years concurrent for failure to appear first, and a 1 year consecutive sentence for possession of a weapon in a correctional setting, for a total effective sentence of 36 years flat. There is no victim input in this case. There is an offender accountability plan for the offender. It has been reviewed and shows he has completed, he had a hearing in March of 2021, and since that hearing, he is enrolled in GED classes and he works as a janitor. Utilizing the statewide collaborative offender risk evaluation system, the offender's overall score on the RT falls within the moderate range of risk for recidivism. Mr. Austin, this is your opportunity to express to the board why you believe you should be granted parole. You may begin.
Can I read this? As a child, I thought and I acted as a child. Now that I'm an adult, I have done away with childish things. I humbly ask this parole board to grant me parole because I believe that I've earned the chance to show that I could live a law-abiding life outside the prison walls. When I say I believe that I have earned the chance to show that I could live a law-abiding life outside the prison walls, that is to say that I put forward my best efforts to meet the recommendations that the board put forward at the time of my first parole hearing in March of 2021. It was the board recommendations that I participate in positive programming and remain disciplinary report free. I did everything that I could possibly do as demonstrated by my many inmate request forms submitted to this board to no avail to enroll in any available programs at the prisons that I've been housed at since the last time of my parole hearing to the present. However, I was admitted into the job program working as a janitor for the prison in Virginia and at the Corrigan Correctional Center upon my return back to Connecticut. Since my last parole hearing, I was permitted to participate in the school program working towards getting my GED. I passed the social studies, science, reading, and language arts sections of the GED test. I am currently waiting on the prison to set a date for me to take the math section, which is the final section of the GED test. Once I take the math section of the GED test and pass, I will have obtained my GED. But I do not plan on stopping my education with obtaining my GED. During my incarceration, I completed courses in how to do your bid, building the ladder, and anger management that taught me anger is one letter away from danger, a model that I live by today. Upon my release, if granted parole, I plan on enrolling in an apprenticeship program where I will finish getting my GED, simultaneously building a career as a plumber or carpenter. I have a solid support system by family and friends. I will try to establish a relationship not only with my son and grandchildren, but with my nieces and nephews, as well as society as a whole. I plan on utilizing the resources provided by family, friends, and a halfway house to overcome the many challenges that I know awaits me if I am granted parole. I've never lived life as an adult in the free world. I've been incarcerated since I was 16. Therefore, I do not know what will be my biggest challenge if granted parole. I can assure this board that one lesson I've learned during my incarceration is how to overcome challenges that may come my way. Hard work and dedication equals success. Since my last parole hearing, I have been able to reduce my overall security risk level from high to medium. Within the Department of Corrections in Connecticut, I am an overall risk level 3. In closing, I would like to say something regarding the victim in my case and the disciplinary reports cited by the parole officer in her report. First, the parole officer cites the 10 disciplinary reports since the first parole hearing to present, some in Virginia system and some in the Connecticut system. These reports may appear extensive for a 3-year period. Although the parole officer did note that there is no way to confirm the Virginia report since they do not exist in my Connecticut file, which is true. I did take it upon myself to obtain those reports from Virginia and submitted those reports to this board for review. I would ask that this board seriously look at the Virginia report before any vote for or against parole is made. I was issued 6 reports in Virginia and 2 in Connecticut since my last parole hearing, and I'll be happy to discuss these reports in more detail if it so pleases this board. Lastly, I would say that I feel bad about the victim and everyone that his death may have impacted. I lost family and close friends to gun violence, so I deeply empathize with the victim and his family. Thank you for this opportunity.
Okay, thank you, Mr. Austin, for your statement. I'll begin by saying we did receive the reports from Virginia yesterday, so we have reviewed them. Okay. In addition, we received a packet from your attorney. We have all of your records from the time of the arrest through now. So we're very familiar with your case. We've taken the time to review it thoroughly. We may have some additional questions now. When we're done with our questions, your attorney and the state's attorney will have the opportunity to speak. We'll deliberate and give you our decision here today, okay?
All right.
And you've been here before, so you know how it works. This is a rehear. All right, we'll begin with my colleague, Ms. Page.
Thank you, Madam Chair.
So, Mr. Austin, I was on your hearing back in 2021. We had discussed at length your behaviors there in the facility. And we wanted to give you another opportunity to come back before us, having completed some programming and showing us that you would abide, or you could comply with the institutional rules, to show us that you were ready to go out into the community. I heard you address some of the things that you participated in since you've been in the facility. And I'm happy to hear that you've made some strides on obtaining your GED, because honestly, that is in your best interest, because when you are released out into the community, that will make you more marketable, because now you have some formal education. Did receive a number of support letters on your behalf from your family. And your son did write a very nice letter of support for you as well, saying he met you through the phone, basically, and that you talk to him all the time about how inspirational he is to you. So I hope that you mean that, because I'm sure that he's looking forward to your return to the community. I did appreciate also your apology in your opening statement to the victim. This is a horrible offense, and there's nothing that we can do to really change that, but we can, moving forward, try to change the behaviors that brought you to prison in the first place. So with that being said, I know that you were housed in Virginia. And how long were you in the Virginia prison?
Excuse me, I didn't get the last question. You said how long it's been?
How long were you in the Virginia prison?
From 2017, then I came back 2018, then I went back out 2019 and came back June 9th, 2022.
Okay. And was it because of your disciplinary infractions that you got being transferred out, in and out?
Well, no, it was because the Department of Corrections felt that I would do better in a different setting. So that's why they sent me out the first time in 2017. And then I came back in 2018 due to a legal matter. And so then we settled the legal matter. And part of the settlement was the out-of-state transfer.
Okay. So you sent to us your disciplinary infractions from Virginia. And we, as the chair said, we reviewed your file extensively. So I'm not sure what you were hoping to accomplish by sending those disciplinary infractions. Explain to us what you wanted us to see.
Well, I wanted y'all to see that the disciplinary infractions, it was minor. They gave me, to my recollection, 2 infractions for sagging my pants. Another infraction for not using a grievance for the stated reasons that I said I was going to use the grievance for. Another infraction for taking 6 extra minutes when I was allowed a 10-minute shower. So what I was trying to show to the board is that I'm not trying to hide the infractions, you know what I'm saying? And in the sense of being transparent, the parole officer said that there was no way to confirm what the infractions were. So I wanted the board to seriously look at these infractions, that they was not of no type of violence, not even of no type of disruption or anything in that nature. It was minor. And some of them was like, well, the one that the grievance one, I couldn't predict that. I couldn't predict that I was going to get a charge for not using a grievance for an initial reason I asked to use it for. I didn't even know that was even an offense.
Okay. I can appreciate your explanation, Mr. Austin, but for me, in reviewing your disciplinary infractions, I did not see violence, but what I did see was non-compliance. And that was our issue with you when we saw you the last parole hearing. It's important that you follow the rules. period, regardless of what you think is minor or major. If I go out here and the speed limit is 55 and I continuously drive at 90, to me, it's minor because I got to get to where I'm going. But the rules are the rules. So if I get pulled over, you know, I'm going to get a ticket and possibly, you know, have my license revoked. You understand what I'm saying? I know that it's an issue. We can't just do whatever we want to do and think that, especially when you know that you can't sag your pants. Because the ticket said they told you not to do that, and you still did.
Can I say something in that regards?
Absolutely.
Well, I know what the ticket say, but I submit to you that if you look at the charge, the officer said I had my pants around my waistline. What I'm not trying to do here is be combative. What I'm trying to show the board is that these tickets, and I fought the ticket. These tickets was minor and is not indicative of me being disrupted. That rule, I didn't even know it was a rule in the first place. And if you look at the circumstances of one ticket, he said I came out to dump my trash. And the trash was out right outside my cell door, and they gave me a charge for that. But what I'm saying is that I'm sorry. I'm sorry for the tickets. I didn't know that was a charge. I didn't know I could get a charge for not using a grievance for the stated purpose.
And you're talking about one ticket in particular, the grievance one you didn't know. I understand that, but that does not negate the other disciplinary infractions that you've received. I have to be honest with you, Mr. Austin, and I know that you're trying to speak, but when we have these parole hearings, we have to justify our decisions. And it's really difficult to support an individual who comes before us and they have 236 disciplinary infractions over 24 years. You know, when we have people that sit before us with less than with the same amount of time, I'll say, and they have 7 tickets or no tickets. So it is possible, you know, and I understand your recent disciplinary infractions and the explanations behind them, but how do we justify that Mr. Austin has been down for 24 years and he's taken minimal programs, he's received a number of disciplinary infractions, and we're fairly certain that he's going to go out into the community and do what he's told and do the right thing when you're not showing us that in the facility? It starts where you are. You have to make the best of it where you are. And all the things that you say that you want, and you know, and the letters and stuff that we read for you, we want the same things. We want you to go out and be successful. We want you to reunite with your family. We want you to get a good job doing plumbing. That's a great, you know, goal. But you're standing in your own way, Mr. Austin. You really are. You know, and I wish that this conversation was different because I'm disappointed that you couldn't do what we asked you to do. I really was hoping to read your file and see that you had done so many things, being a mentor or something, you know, speaking out against gang violence or something, anything positive. And that's not to negate your strides that you've made again with your GED. But this is a lot. When we're dealing with a heinous crime and we're dealing with someone who hasn't really taken very many programs in the length of time that he's been there, but he's accumulated a number of disciplinary infractions, it's hard to say that this person has changed.
No. I tried. As far as the programs went, I tried. I requested for the programs. They say you're on a waiting list. I never got in it. Then I get transferred to a different facility and I start the process all over again. I wasn't transferred to a different facility because of any disciplinary infractions, my level was going down. So when I was in Virginia, my level went down, and I went to a different facility. So I had to start the process all over again at that facility. Then my level went down again. So I had to start the process over at that facility. Then I come back to Connecticut. Then I had to start it over again. Then I get transferred to Core again. My level go down. I get transferred to Osborne. So I had to start this process all over again because my level is going down. So it's not like I'm sorry.
Go ahead. It's not
No,
like.
it's not like that. It's not like that. I'm just sitting back in prison and just waiting on something to happen. No, I'm trying. I try to get into these programs to demonstrate what you expected me to demonstrate, but as the request said, they tell me I'm on a waiting list. The only thing that was available was a janitor level job, which I participated in, was GED, which I participated in. And I know y'all concerned.
Go ahead.
And I know y'all concerned about these disciplinary reports and the amount from my incarceration to now. But at the beginning of my incarceration, and I'm not blaming nobody, I take responsibility for it. I was young. And where I was at, I was easily manipulated. I thought that was, cops and robbers. I thought I was supposed to side with the inmates going against the officers because that's what I was taught. I didn't have nobody. All I had was other inmates telling me this is what it is. You see what I'm saying?
I do. You grew up in prison.
Right, but I'm not trying to justify the tickets. I'm not trying to say I didn't catch the tickets. What I'm trying to say is that if I would have had somebody, I want to go the tickets. Them other people you named probably had people. I didn't have my mother on my side. My sisters, they just came around. You see what I'm saying? I didn't have none of that. So when you compare my disciplinary history to theirs, you gotta understand, I'm 16 by myself, literally by myself. Nobody took care of me, nobody. So, and then I found out I got a son. He was taken from me. His mother didn't let me see him. I just started talking to him when he was 17. So when I'm in the system, I got nobody. I'm facing this charge. All I'm thinking about is my environment and what they telling me. And then the COs making it seem like that's what it is too, because, I'm not trying to say that. What I'm trying to say is that, listen, I understand the history in my record, but if I would have had someone come and sit me down and show me a different way, then I probably would have did that. I probably would have took that different way. I probably would have acted better. But it took me time to realize this is not what it is. And when I realized this is not what it is, this is not how you express yourself, I did started to change that and use different ways to say what I needed to say, to tell them like, this is how I want to be treated. And my behavior changed. And if you look at my disciplinary history from then and now, sagging pants, grievance, 6 extra minutes in the shower, yes, they are tickets. Yes, I did receive those tickets, but I sent them to the board to show y'all in comparison that I'm trying and I've been trying. And I just don't know what else I can do. I really don't.
All right. I appreciate your explanation, Mr. Austin. I would encourage you to continue trying, and continue working on yourself and continue trying to be the best person that you can be. Regardless of what happens, it's what you really think about yourself. And I do understand that you were a kid going into an adult prison and having to fend for yourself. I do understand that. And there are, you're not the first person to tell us that. But, our job here is to release individuals back into the community who we believe will be law-abiding, contributing members of the community. And I just don't know that we have enough to support that for you, is what I want you to understand. So I do appreciate your speaking with me. I appreciate the submissions by your attorney and all the hard work that you've done in there on yourself. And I still, again, encourage you to continue working, continue trying. And I do wish you the best. Thank you, Madam Chair. Thank you, Ms. Page. Mr. Austin, we do understand your dilemma and your frustration. We understand that it is sometimes difficult to get into programs when you have a lengthy sentence. We also understand that when you get tickets, you go to the bottom of that list. Were you aware of that?
But see, I was ticket free.
Yeah.
When I submitted them requests. So I was on the waiting list. I just was at Osborne. And one of the requests, it says that I'm on the waiting list for these programs. And I've been on the waiting list for them programs.
Right.
And I wouldn't have got transferred to Mandoo. Now I would have stayed at Osborne, but the situation was that I had to get transferred because I got into a little situation with the officer, but she already had situations prior to that, and they transferred those inmates to Brooklyn and Carl Robinson, which is the only two facilities that I could go to with my level. So since some other inmates had profile with her, they couldn't transfer her, so they transferred me here. I'm still a level 3. I'm still a medium. And I submitted the request to this facility to get in the program, and they gave me the application for the vocational. But since I have more than 3 years on my sentence and haven't been voted to parole, I couldn't get into that program. So I'm still on the waiting list for programs. It's not like I can't do the programs. I just gotta wait for the availability. And can I just say one last thing about, the chance, like, no matter what the record is, well, it do matter what the record is, but if I'm not given a chance to show that I can live a law-abiding life on the street, then nobody would never know. You can have a record that's absolutely phenomenal, and that person go home and commit a crime. And you can have a record that's not that phenomenal, and that person go home and be successful. So if I'm not never given this chance to show that I can do this, even though I may have these amount of reports or I have not participated in the program, then no one will never know. I'm just asking for that opportunity.
So let me explain to you, we don't just give out chances to everybody. It doesn't work that way because we have a lot of problems if we just handed them out. So the only thing we have to measure is your behavior while you're incarcerated. That's all we have. So you have to understand our dilemma, just as I understand yours. You have to understand our dilemma as well.
Absolutely.
So let's move on from that. I did review your last hearing, and I have questions. We're not going to retry the case. I don't want to go over every detail, but at your last hearing, you denied committing this offense. You said you were innocent, and in fact, I believe you were still in court trying to fight the case. So where do we stand with that now?
I'm still in court. I'm still fighting the case. And
do you have a habeas petition packet? Look, what are you going to court for?
I got a habeas.
Okay, and what is the basis of that habeas?
Is many bases of the habeas. One issue is actual innocence. The other issues is, prosecutorial misconduct. And just because I maintain my innocence doesn't mean I can't sympathize with the victim and his family. The person is dead. He's not coming back. And I sympathize with that. And I sympathize with his family. But that don't mean that I did the crime. I still maintain that position. But I am sorry that person died.
Yeah. No, I heard you say that. So the habeas was filed when? How long has this proceeding been going on?
Well, I filed 2 habeas. The first habeas was filed the same day my appeal was decided, which was back in 2005. That habeas went to trial in 2013. Then I filed another habeas. Well, I filed the federal habeas. The federal habeas is still pending. Then I filed another habeas on habeas counsel in 2013, and that just was concluded. And last year.
Okay. All right, so you have one pending, you said,
In federal court.
in federal court, okay?
But the habeas in state court is all on appeal.
Okay. All right, so you still deny committing this offense. Did you know the victim in this case?
Absolutely not.
You never sold him drugs?
Like I testified at trial, I was out there selling drugs, so I may have. I don't know.
Okay, and during your last hearing, you proposed that you wanted to go live with your sister. And now you're saying you want to go to a halfway house. What changed?
She moved to North Carolina. And I feel like the halfway house, well, I got another sister that live in Connecticut that she said I could go to her house, but I feel like the halfway house, it would be a gradual transition and just instead of going straight out there into the world.
So let me ask you, sir, what program do you think you would benefit most from?
I don't know. That's why I asked for any available programs to see which ones that I would benefit from.
Well, did they give you a list? I mean, can you do your own research on what the programs are all about?
The programs that they told me was Voices, that's about domestic violence, AA, which is about Alcohol Anonymous, tier 1 through 4, which is all drug programs.
Yeah, Voices is about victims. It's not about domestic violence. Domestic violence is about domestic violence. Okay. And do you think any of those programs would benefit you?
I don't have a problem with domestic violence,
Right.
but knowledge is knowledge.
And I understand that you're eager to get out. Of course, you would be. You've been incarcerated for 24 years.
Right.
Anybody would be, and you were young. You were 16 years old when you came in here. So it's not possible for you to be the same person because you're not 40.
Right.
But we have to feel confident that we wouldn't be posing a risk to the community at all, you know. All right, I'm going to turn it over to my colleague, Ms. Palmieri, for further questioning. Thank you for speaking with me.
Thank you. So, Mr. Austin, I did also listen to your first hearing with my two colleagues. And, you know, in conclusion, they determined that you hadn't really shown rehabilitation, that you hadn't taken any programs, and of course, the disciplinary report. So probably the one thing that was in your control was the not getting any disciplinary reports. And when I went, having been the new person looking at it, I went through your disciplinary history. And one of the things I did was I kind of aged you along, right? So early on, you got a lot of tickets and 39 before you were even sentenced, right? So when we do these hearings for individuals like yourself who were, you know, very young, 16, 17, going incarcerated, we generally see a good number of tickets probably in the beginning, but then they start to dwindle off, right? They go away because you get older and you get more mature, right? You learn that your decisions have consequences. Do you think that's true, that you're able to look at your decisions or your choices and determine what will be the consequences of your choices?
Absolutely. Absolutely. And the reason why you see the tickets seem to be a continuing pattern is because I was in Northern, and that's the program is you got to remain ticket free to get out. So the more tickets you catch, the longer you stay in there. So since I was just from a young age and I'm catching these tickets, I'm staying there longer and longer and longer. And the mind state that that I allowed myself to get in was cops and robbers, us against them. And then I started realizing the same guys that was preaching this to me, they're now out. They're getting out. And they're not looking back at me. You see what I'm saying? So then that's why I started realizing, I got to start thinking for myself. So that's why you'll see as time get more closer that the tickets become few in a year and fewer and less, disrupted, less as, I'm covering a window and going at them.
So what I'm because you already had sort of explained all this, and I think we all appreciate that you see your tickets decreasing in significance, maybe is the word, right? So where you were fighting and threatening, and now they're more sort of what you would consider insignificant, not pulling your pants up to your or that type of, and covering your window, having a clothesline, I saw was one of them. So I do see, but I have to go back to what my colleague was saying. The rules at the facility, as the rules of society, are there for a reason, right? So if the walk sign is out in the communities are there so people don't get run over, right? So that, right. And so cars know when to stop. I mean, the rules are there for a reason. And at the age of 39, 40, 41, you need to be in a place where, it just comes naturally that you're following the rules, not sort of just doing what you want and thinking it's not such a big deal because it's not a violent, it's not hurting anybody. Can you think of an example recently where maybe you thought through the consequences and you made a decision that kept you out of trouble or brought something positive to you?
Every day.
So give me an example, though. Give me an example.
There's things that's going on in prison in my own environment, which means in the unit that I am in, that I keep myself away from. I don't involve myself in the things that's going on down there. I ignore it, I mind my business, and I do what I gotta do to help myself. I don't argue with staff members. Staff members tell me to lock up. I don't wait till they say last call, I locks up. I don't set myself in a situation where I have to explain why this happened. Because I am following the rules and I'm giving it my best efforts.
Okay. All right. Well, I think that's the right attitude to have. Kind of getting in front of things, like you gave an example, locking up before they call the last call for it. I think those are steps in the right direction in terms of thinking what's the right thing to do. So when you were interviewed by the parole officer, you said you wanted to reinvent yourself. So right. What does that mean to you? What would it mean to reinvent yourself?
To create a different perspective, outer perspective of myself that people may have when they hear about me or look at, my disciplinary record, because my disciplinary record is not indicative of who I am before y'all today. And I understand that. And I don't want the board to think that I do not understand where y'all coming from. I do understand where y'all coming from. I understand that. I understand that y'all have a job to make sure that the person before y'all is gonna go out there and not commit a crime. And I'm telling y'all, and I submit to y'all that I would like that opportunity to show y'all that I will not commit a crime. And I understand these reports. I'm not trying to say they don't exist. I'm not even trying to justify it.
I want to just harper back to my question. how do you see yourself reinvent, being a different person in the community? What kind of things do you think you'll do to prove that you're not that, as you called yourself, you don't want people to see you that way? So what do you have to do to dispel that view?
I'm gonna go out there and I'm gonna get a job. I'm gonna take care of my son, my grandkids. I'm gonna go to school, and I might go to school and take up some law because I got some suggestions from lawyers to come work for them. But I'm not sure if I want to go that route. I just want to put all this legal stuff behind me and live a normal life. I want to, you know what I'm saying, to be a plumber or a carpenter. I want to show that I'm not violent, I'm not disruptive, that I am a law-abiding citizen, that I could be a law-abiding citizen and follow the rules of society and live a normal life.
Do you think that you've taken good advantage of the time since your last hearing?
Absolutely.
You've made good use of your time?
Absolutely. Absolutely.
Think about being back home, out in the community. What do you, when you think about it, what do you think will be the hardest thing to do? What will be most challenging?
Probably adjusting, you know, filing taxes, you know, being away from society for so long. I really don't know. Like I never lived out in society and had a job. I was 16 when I came to jail. I never had a license. I never had a car. So those things might be challenging to get adjusted to all those things.
Okay. So, you know, one item that we sometimes get from individuals who've served a long sentence, like yourself, and gone in at such a young age, is like a 5-year plan where you start to think about how it will be to live in the community and beginning to do a few of those things that you just mentioned. Driver's license, bank accounts, signing a lease for an apartment. I mean, all things you as a 16-year-old never did and never had any thoughts about doing, right? So those are some things that would be good use of your time going forward also, is to think about how, when you're back in the community at whatever point, how you're going to begin the process of settling it.
Yeah, and I thought about that. That's why my support, the person that's going to give me a job, also has the apprentice program to complete my GED. And he's going to help me file taxes. He's going to help me get established. He also owned property. He also owned his own 3-story family house. So
is this Henry Smith?
Correct. And not only Henry Smith, but Ernest Pagan too. They also own property too, which could set me up with housing once I gradually transition from the halfway house. That's why I wanted that.
How do you know Ernest and Mr. Pagan and Mr. Smith?
Oh, when I moved to Connecticut, when I moved to New Haven when I was young, we lived in the same neighborhood. I know him all my life.
But, you know, I do think a plan of an apprenticeship where you get your GED and develop some sort of vocational skills is a great plan. You know, for you, I think that's reasonable, it's meaningful, it's achievable, and it would provide you an opportunity to be self-sufficient. So I do think that is a good plan. I would agree with you, and I would hope that you will stick with it.
I will.
Okay, great. All right, Mr. Austin, thank you very much for answering my questions. I have nothing for you, Chair.
Can we please confirm with the Office of Victim Services that outreach was done in this case, Ms. Hamlet-Lambs? Thank you.
We're gonna do it. We're gonna keep. We're gonna go off the.
Yeah.
Madam Chair, can you hear me?
Yes.
Okay, thank you. Good morning, panel. Good morning, everyone. I did speak with the family and they will just be viewing today.
Thank you very much.
Thank you.
Time, the attorneys will be afforded the opportunity to make a statement. We will now turn it over to the state's attorney. Do you wish to proceed?
Yes, thank you, to the board, and thank you for the opportunity to address you today. I apologize. I was looking at my notes. I didn't know I was going first. I will address, just a couple things. I think that, I just want to, note something that I thought was very important that the chair mentioned this morning, which is, balancing, not only under the statute and efforts by an individual who's in custody being considered for an early release pursuant to the, 1584 statute. The statute is very clear that the board needs to look at what efforts, and you've been outlining that with the questions that you've asked Mr. Austin this morning about what efforts and things that he's done while he's been incarcerated, balancing that against the crime that he's committed, which, by the way, he's been committed, he's been convicted. It's been brought up on the appellate court, the Supreme Court, and just to illustrate to the, and I'll get to some of these in a moment, but the board, there are at least 19 separate legal decisions by 19 separate judges regarding Mr. Austin's matters. And that's beyond the regular appeal and the denial of cert and the other appeal, and then a variety of the habeas matters and other matters that he's brought. But we're sitting here today with, and as the chair had noted, that you're going to balance the issues of individuals who've accepted programming, who have attempted to rehabilitate themselves in the time that they've been in custody, and balancing it as Connecticut General Statutes 54-125A indicates against the overall degree of such person's rehabilitation, considering the nature and circumstances of the crime or the crimes. So no doubt, when he was 16 years old, although he disagrees and won't accept responsibility for it, a Superior Court jury sitting in New Haven found that Mr. Austin took the life of another individual. He was sentenced by Judge LeCarry after a criminal jury trial after 12 citizens of the greater New Haven area found him guilty of that particular offense. It was a position of the state and has been for the last 24 years that he was sentenced appropriately by Judge LeCarry at the time. Now, under this statute, you have outlined what you would have to balance. What I would ask the court to consider, what the board to consider is that you have an individual in this dilemma here seeking to get relief under this particular statute, but is now still not accepted responsibility for his behavior, does not view his behavior, his activity as to be relevant to whether he should get out in this board. Over the last 24 years, as I've indicated, he has filed a number of motions, which the best that I can describe is putting aside his initial appeal, as which happens normally, and his initial habeas complaint. He has filed at least 7 or 8 habeas complaints against a variety of lawyers, attorneys, correctional officers, correctional facilities, and that's where Mr. Austin spends a large majority of his time while he's been in custody. I also reviewed notes and the hearing when he was previously before this board up under this particular same statute. And the board did address the fact that it's been brought up by its members this morning that Mr. Austin was directed, denied discretionary parole in the previous things because of inadequate institutional program participation and evidence of offender change. The court also noted, the board also noted injury impacted the victim or the victim's family, and then poor institutional adjustment. I did attempt to reach out to the victim's family. I believe they may have been online, but what I also want to point out to the board is that in a lot of situations like this, it is very difficult for a state's attorney or prosecutor to continuously have to reach out to victims. I do not know why they don't want to speak today. Perhaps they just want to observe, and that's fine. According to my notes, I'm going to be objecting to Mr. Austin being released on this parole on their behalf. And I do want to point out to the board, just in the last 6 months, they've had to be contacted about a sentence mod application he filed, a motion to correct an illegal sentence, which is still pending here, several habeas matters that he's been pending here, and a variety of other motions that Mr. Austin has filed. In the time that he has been incarcerated, what I notice as a pattern is Mr. Austin between DOC, perhaps the Board of Parole, perhaps his parole officers, anybody interviews them, judges, attorneys. I do not know Attorney Wilson, but I feel bad for her because I predict at some point she's going to have a habeas against her because he's filed it against every single lawyer who has ever represented him. Ironically, a few months ago, where rather than engaging in a program, is that on one of Mr. Austin's habeases, Mr. Austin sent me a letter, and that which he was questioning my authority as the state's attorney to assign one prosecutor to handle his habeas matter as opposed to another prosecutor. So there is a pattern here. I think when you have to balance, yes, the young age of Mr. Austin when he committed this offense and efforts to rehabilitate or mature himself, that hasn't happened because he continues to address anybody that's in an issue of authority as evidenced by his disciplinary tickets, as evidenced by correctional officials, as evidenced by attorneys, as evidenced by judges, as evidenced by prosecutors, and the variety of claims he made against him, which are his right. I would indicate that most of these are done pro se, representing himself, both in decisions by Judge Newsom, Judge Oliver, Judge Harmon, and a variety of other judges, as well as the sentence review panel. The common pattern here is he will get the decision that he doesn't want, relabel it and remodel it, make the same claims again in the future in another motion or hearing, which is hence why we have 19 decisions and he has currently 3 matters that are pending here in New Haven Superior Court. I don't know what he currently has pending up in habeas court. I am indicating to the court that when you look, to the panel, when you look at the underlying activity that he was convicted of, yes, he was 16 years of age. Yes, you have to balance that versus his efforts to rehabilitate himself. And those efforts fall far short. This panel and this board has to address these issues under this statute quite often. I know quite often you're going to be in situations where a prosecutor such as myself is going to recommend that this not occur, will also be objecting on behalf of families or victims would be objecting. I was here last month on 2 young men charged with murder that this board made the decision to release them in May or June. What I would say to this board is, you have a tough job. You have a lot of things to balance. I disagreed with those 2 men being released in June, but I understand your acceptance responsibility. You all have burdens. We all have decisions to make. But I would indicate the pattern of this defendant would be a disservice to those 2 young men 2 weeks ago that you balanced all those interests, saw the strides that they made, the acceptance of responsibility that they made, the efforts that they're going to go out and try to better themselves in the community as compared to Mr. Austin, who I don't think has that ability at this time. That's all I have. Thank you very much. And thank you for allowing me to address you.
Thank you, Attorney Jones.
We will now turn it over to Attorney Wilson. Do you wish to proceed?
Yes, please. Good morning. I'd first like to thank the board, Attorney Doyle, and everyone here for allowing me to address you today. I do feel that Mr. Austin did a wonderful job, reading his statement and answering your questions. And I don't plan on badgering you on information you've already heard from him, found in our submissions, any of that. But I do want to talk about my personal experiences with Mr. Austin, because I feel like it will give you an insight into who he is as a person beyond his institutional record. So I was assigned to his case just a few months ago, pretty recently. And of course, before I met with him, I reviewed his institutional record, got the DOC records, all of that. And I really didn't know what to expect with meeting him. Of course, I knew about his previous lawsuits. And, I tried to go in with an open mind. And I can honestly say that he surprised me. All of our meetings have been positive. I find him to be a very mild-mannered, kind, understanding person in light of such a stressful and difficult situation. Preparing for hearings like this, I'm sure, as you know, can be very stressful. And it brings up a lot of tough things to discuss, including, his institutional history and his time in DOC. And, we've gotten to know each other. I've spent a lot of time with him, and I've honestly gotten and grown to really enjoy our time together. I do think that he has grown a lot since his time in DOC. He went from, committing violent offenses or disruptive offenses, as he spoke to being much more respectful, and you know, he has improved his institutional history. I think it's important to note that while he has filed lots of lawsuits and other things like that, as Attorney Doyle spoke about, one, that is his right to do, and two, that is his outlet. That is what he has taken to deal with all of the frustrations that he's dealt with within DOC. And as we all know, the Department of Corrections is not an easy place to be or grow up. And, you know, realistically, he has grown up in this system. This is where he became an adult and kind of learned to deal with his emotions and all of the things that come his way. And the way he's addressed those is through the legal system, which is much less disruptive than, you know, picking up violent DRs. So he has studied law, he has helped himself, he's helped others. And it's also important to note that when he came into the Department of Corrections, he was generally uneducated, and he took the time to read and write and learn outside of the typical programming offered within DOC. So even though he hasn't had the opportunity to be in all that programming, he has taken his own initiative, even beyond his GED, which is fantastic. He only has one section left to receive his GED, but he read law books, he read regular books, he took every opportunity to learn. So that's kind of addressing the board's questions about his programming. I can also say without a doubt that he is committed to being successful outside the Department of Corrections. When he was in Virginia and even, you know, time in Connecticut, he did have a year period where he did not pick up any disciplinary reports, which I believe shows that, you know, he can understand the rules and follow them. And, you know, he has realistic plans for when he gets out of the Department of Corrections. He mentioned that he wants to go to a halfway house, which is something we've discussed at length, that there are resources that are available to him in the halfway house, including counseling, job resources. He's willing and wants to go to counseling to be evaluated, you know, even though he doesn't feel that he has mental health struggles. He also understands that a transition into the community will bring struggles and potentially bring mental health, you know, struggles, and understands that there is help for him out there. He has plans A through Z when it comes to working. As he mentioned, and as we submitted, he has job offers. He has family members who are very involved in their churches, and those churches also have programs that can help him get a job. And he knows that halfway houses also have those programs. There's job assistance, helping him with a resume, that kind of thing, and he plans on utilizing them. Another important part of this is his family support. He did mention that they recently came around, but I can tell you that in my interactions with his family, they have been very supportive, very willing to help, you know, very receptive to my many emails, and especially his son, who, you know, he met, he did not know existed until a few years after his incarceration. We've had extensive conversations about the relationship he wants to build with his son and his grandchildren, and I think that that's really important. He wants to be successful so he can maintain those important relationships that are really hard to build while in DOC. So in closing, I'd just like to reiterate that Ira Austin is much more than you see on paper. He's someone that I've grown to enjoy spending time with, and someone that I think is really dedicated to being successful outside of the Department of Corrections. And I think he is deserving of a chance to show that he is able to be successful. So thank you again for your consideration and for hearing us today. I know you have a difficult job, and we really do appreciate it.
Thank you, Attorney Wilson. Okay, so at this time, Mr. Austin, we are going to enter into deliberation. Everyone is free to listen to our deliberation, and we'll come back to you with our decision.
Thank you, Madam Chair. So I appreciate everyone recognizing that our jobs are difficult, because they are, you know, and I would also acknowledge that Mr. Austin's attorney is right, and she wants us to see him for more than he is on this paper, and unfortunately, that's all that we have to go by. We haven't had hours and hours
I don't have to do wrong.
to develop a relationship with him and know what kind of person he is. We do that every single day that we're here, you know. So I appreciate her speaking so passionately on his behalf. But when he was before us, I think that we showed him a level of compassion. I think that we extended the olive branch that, you know, we believed that he could accomplish what we asked him to do. So we gave him another opportunity. And unfortunately, he disappointed me in that, you know, he came back with a whole bunch of disciplinary infractions. We would be having a different conversation, I think, had he been compliant, you know, but that's not what happened here. He didn't take the programs. He did not refrain from incurring any additional disciplinary infractions. And I heard his explanation about the programming and things like that. And I am thrilled that he was able to he's working on his GED, and that he's an avid studier of the law.
Mhm.
You know, those are wonderful. However, when we're looking at this and we have to justify decisions, I don't think that he's risen to the level that we need him to show that there's evidence of change and that he will be successful. So for me, I am going to vote to deny his request for discretionary parole today, based on his reports to tell investment and that adequate evidence of offender change. I would be willing to rehear Mr. Austin, if you all are agreeable to that, another chance. But today it's no.
Thank you. I agree with everything you said. I do see some growth. I will say that he does seem motivated to get his GED, and he's working. I do see some growth, but as far as our purposes here, there's not much movement from the last hearing 3 years ago, and we certainly would expect that in this type of hearing, as Attorney Doyle mentioned. We saw people in similar situations a few weeks ago who had done just so much. It was so compelling, right? That really there was no option to deny them. They had grown and rehabilitated so much. So this is kind of the opposite where we are today, where we don't see any movement. But I would agree, there's a flat sentence here after such long incarceration. I think we'd be doing the public a disservice if we didn't rehear the case, because he will need some kind of transition and support. So, I mean, what happens at that time, if we give him another hearing, is up to him. I mean, right. He's going to have to find a way to grow on his own and stay out of trouble and volunteer and ask for, just the same way other people in his situation do, opportunities within the facilities. So I would agree. I don't think that we're there yet, but I would be willing to take yet another look at this case. Ms. Palmieri?
I don't have much to add to what's already been. We all sort of we hear the same thing and see it demonstrated through his record at the Department of Corrections. I did, note to myself, one of the positives, he does have this 18-month window with no disciplinary report.
Yeah.
Which I think speaks to the fact that he can do it. He can follow the rules. He can manage. Because when I look at the disciplinary reports, I say to myself, yes, they're less, they're minor in nature compared to the fights and the threats and the aggression, but they were so avoidable. They are just really a demonstration of wanting to do what I want to do, which does not help us in seeing that change and that ability to conform with the rules when you're out in the community. And for Mr. Austin, he needs hypervigilant that he has this criminal history, that he's been in jail for a long time.
Yeah.
And you know, he's going to be held to a standard of following the rules, and we want him to be successful. So not giving him an opportunity to maybe go back and try to move forward without any more disciplinary reports and really kind of advocate for himself.
Right.
To get into some programs that will help him appreciate to a greater degree how he can manage being back in the community. Because being 16 years old, spending all that time at Northern,
Right.
being back and forth between Virginia, you know, he does not have a lot of support. He's fortunate to have his son and his sister, but he's going to need some skills coming out to manage his emotions, to manage his frustrations. And I think that I'm hoping that he can appreciate that and appreciate, as I would also like to rehear him.
Yes.
To appreciate the opportunity that the board is willing to not give up.
Right.
And give him the opportunity to demonstrate that he can come out of the community and reinvent himself, as he said. So I agree that he has not demonstrated the rehabilitation that we would need to grant parole today. However, I think that there is an opportunity for him to still work towards it.
All right, so the Public Act requires a minimum of 2 years for rehearing a case. Thoughts?
I have had another 3 years, I say.
I mean, I could go either way, to tell you the truth. 2 years gives him roughly 8 years left out in the community if he were to bring himself before us. Does that give him enough time to do some programs? Probably. To do enough programming to demonstrate that level of rehabilitation. Would have to, but maybe that's what we want him to do. 3 years.
This person's not supposed to be easy, you know, and you have to start trying to make some connections there in the facility so that you can advance.
I mean, Ms. Page, you've said a number of times, you shouldn't want to be there, right? It shouldn't be a place where you're comfortable and happy to be.
So, all right, I'm at 2027, Madam Chair.
Yeah. Right, in the matter of Ira Austin, I mean, number 275666. I make a motion to deny parole at this time for the following reasons: inadequate program participation and evidence of offender change, and poor institutional adjustment. We'll rehear the case in March of 2027, 3 years from now, and with the recommendation that you avoid any more disciplinary reports and that you participate in positive programs, school, work, whatever programs you can be a part of. Anything you can do to aid in your rehabilitation. Is there a second for the motion? There is. All in favor? Aye. Okay, sir, do you understand?
Yes.
Give you another shot at this. Let's see what you can do, sir. We wish you the best. Thank you, Attorney Wilson, Attorney Doyle, for participation.
Thank you.
This concludes the 1584 hearing for Ira Austin. It is 10:07 a.m.
I got my own. But if it's certain things they want from me, that's what they want from me. Like, I just think my thinking. Why would I do that? You know what I'm saying? We need to get the power of somebody else.
Well, how do we unpack this? For one, 236 write-ups, or as they call it, tickets. that is up there. From my memory, I can only recall if maybe we've seen 2 or 3 in Louisiana that had above the 200 total write-ups, and they had spent maybe 50 years in prison. This is, this is really interesting, and how the DA said, I feel bad for his attorney because he's filed those lawsuits against every single one of his attorneys, and that's never a good sign. It's we'll go over the court documents soon of his appeal for the crime, and we can try to come to a conclusion whether maybe he's innocent or not innocent. But there's one thing to kind of claim you're innocent and take that approach. There's another when you are literally fighting everyone who's ever in your corner. I mean, to file habeas corpus against how many attorneys did he mention? See, that's not a sign of innocence. That's, in my opinion, a sign of something else. And like there's something wrong with you, kind of thing. I mean, that's just not a smart thing to do. And I do feel bad for his attorney. And even the way it ended, she had to do the best that she could do. And but even the way it ended, he kind of like didn't look at her, didn't say thank you, it was like, oh, again, it must have been her fault. That was almost my takeaway from it. But also my takeaway here, which is, of course, the DA shows up, and he probably shows up because he's sick and tired of this guy being the nuisance that he is, with all of these appeals and court hearings and motions. The idea that there are 19 decisions with 3 pending, and Richard filled up my spreadsheet with these, the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. I think we have about 19 in my own spreadsheet, and I want to scan through them. And he has things from suing correctional officers for being maced. He's every time there's so much in there, I couldn't go through all of it, but it's not, he's a nuisance to the system, to say the least. And so the DA decided to show up. What was a little bit frustrating to me is that immediately after this, there was only 2 hearings held this day for these type of cases. Someone who was under the age of 18 that was given a long sentence. And the next person to show up right after this was a monster who sexually assaulted and then killed his 4-year-old cousin. And guess who didn't show up? Yeah, the DA didn't show up to that. So, it was just interesting. And I don't know if it's the same jurisdiction. I know it's that word. Or if it's, was it the same office? Because if it was, that is sick, that you'll show up to this just because he's a legal nuisance. But man, it's like he just doesn't get it. He says, he had a hearing, and what he had to do to get parole for his freedom, all he had to do was not get write-ups. But meanwhile, he shows up as a level 3. How are you going to get commuted? How are you going to get sent out of prison early when you're considered still a level 3 risk in the TOC? And then and I get that the write-ups aren't violent write-ups, but he just doesn't seem to get it. It's like, yeah, if your pants are sagging and you're not allowed to sag, you can't do it. That's just the way the rules work. You got to follow the rules. And even when you heard the way he was saying it, I went over my shower allowance by 6 minutes or 8 minutes when I was only allowed a 10-minute shower, and I took a 16-minute shower. I was like, yeah, but you're breaking the rules, man. I mean, you're making the decision to break the rules when you're the one who's going to lose most. That's what they're judging. That's what they're looking at. And the idea that you can't get that, or that you can't have the self-control to not be in the shower longer, which is something that is entirely in your control, and that you'll rather take a write-up at your own expense, that's saying something. There's something wrong. And he doesn't seem to get that part at all. it's just like a disconnect. Now, let's go to this crime and see what it was. So the jury reasonably could have found, so he was given, what was it, like 60 something years for the sentence. And then they go into, so the jury reasonably could have found the following facts. On December 8th, 1999, the defendant was standing in the hallway of his apartment complex on the corner of Sherman Avenue. When Bobby Bloodsworth, a fellow high school student, stopped by to visit Early, a friend who lived in the complex. When Bloodworth emerged from Early's apartment, he saw the defendant in the courtyard and talked to him briefly before leaving. As Bloodworth walked away from the courtyard, he saw two men approach on foot and a red car pull up to the curb. Anthony, the victim, exited the car and jumped onto the short brick wall bordering the courtyard. The victim previously had purchased narcotics from various dealers in the building, including the defendant. After hearing the victim jump down off the wall and footsteps coming up behind him, Bloodworth turned around and saw the defendant fire two shots, one of which struck the victim in the chest. Okay, so after hearing the victim jump down off the wall and footsteps coming behind them, Bloodworth turned around and saw the defendant. So here's an eyewitness. He sees the defendant shoot two shots, one that struck the victim in the chest. Bloodworth immediately fled the scene. The victim, meanwhile, died on the pavement. The next day, the detective of the New Haven Police Department called the high school, think of it, these are high school students, because students were discussing the shooting. On the basis of his investigation there, he attempted to find the defendant and Bloodsworth for questioning. So the detective first located the defendant, who was in custody on unrelated charges. So he had already been locked up. Wow. Okay. After, or maybe they had a warrant for him for something else and locked him up. That's probably what happened. After being advised of his Miranda rights, the defendant signed a waiver of rights form and agreed to talk to the police. And that, or unwisely agreed to talk to the police. The defendant proceeded to give statements to the police that at trial he subsequently admitted were lies. The defendant told the police that he was not in the vicinity of the shooting and the night of question, but instead he was with a friend named Lona. He denied being involved in any narcotics dealings, and he claimed that he had never seen the victim before. He also described his clothing on the night of the shooting and as consisting of gray sweatsuit and black boots. All of these statements conflicted with the defendant's subsequent trial testimony. So he testified at trial. So he spoke to he waived his rights and testified at trial. 2 strikes against you right there, right? At no point during the interview did the defendant implicate Bloodworth as the shooter. So, I mean, right off the bat of it, you have one man who's pointing the finger at the other. And so, of course, you might say it could have been Bloodworth, but let's see let's see a little bit more, right? The police department investigated the defendant's alibi and found that it could not be corroborated. The police then confronted the defendant with this information. At that point, according to Valicia's testimony, the defendant terminated the interview. Thereafter, he was released. So after they said, "Hey, we can't corroborate it," he said, "Probably I want my attorney." So, but they released him. Then the investigator, the detective, subsequently located Bloodworth and brought him into the police station for questioning. Bloodworth was frightened and crying and immediately asked to be enrolled in a witness protection program. He thereafter gave a tape-recorded statement about the shooting and identified the defendant as the shooter from a photo board. Several days later, on December 13, 1999, the defendant was arrested in connection with the shooting. You know, this is interesting how they write it out, though. They say that he was, this is a perspective. He was frightened and crying and asked to be enrolled in witness protection. And I can easily see it they write it in the way that it shows he's afraid, he's but who knows how it really went down, right? It could have been like they said, hey, you saw it, or you're going to go to life in prison. We think it's you. And maybe he cried a little bit. He was nervous. They said, don't worry. If you point him out, we'll put you in witness protection. He said, okay. And then, but the way they write it, they write it in the light that they want it to be portrayed. And I just want to point that out. That's probably not exactly probably didn't go down how they wrote it. A trial, Bloodworth admitted, an admitted drug dealer testified against the defendant, right? An admitted drug dealer who was so afraid and crying. He indicated that shortly after the shooting, the defendant paged him and asked him whether he had told anyone about the incident. Early similarly testified at trial, but about the events surrounding the shooting, although she did not implicate the defendant as the shooter since she had not witnessed the homicide. She testified that the defendant's reaction to what had transpired was blank happens. Additionally, several other acquaintances of the defendant testified that they had seen him with a weapon in the days leading up to the shooting. Tyrone testified that he had seen the defendant with a .38 special. It's also funny, he's on the witness protection, but he's listed in here as being a snitch. So I don't know how that works. But anyways, Tyrone testifies that he has seen the defendant with .38 special revolver 3 days before the shooting. This was supported by the testimony of other witnesses who saw the defendant carrying a gun 1 week before the shooting. Although Rich was not sufficiently familiar with guns to describe the specific caliber of the weapon, or physical description of the gun was consistent with Fick's testimony. Her testimony was also consistent with the state's firearm expert, who testified that the bullet that struck and killed the victim was likely fired by either a .357 Magnum revolver or .38 Special revolver, both of which have a similar silver appearance. And it's funny because we have had this exact conversation with the Louisiana Martin Luther King Day Parade commutation hearing, for those of you that remember that. I don't understand though. Can a .38 Special house a .357 round? No. I'm confused about that, right? I mean, 38 would hold a 38. I don't know. The defendant thereafter testified that the story had given to police when she was first taken into custody in December 9, 1999 was entirely false. Her testimony at trial implicated Bloodworth as the shooter. Oh, no, sorry, that he had given to police was entirely false. He implicated Bloodworth as the shooter. Specifically, the defendant testified that Bloodworth was in the business of selling narcotics along with an acquaintance by the name of Drew. On the day of the shooting, he was playing the role of an armed lookout. When the victim approached and jumped the wall, the defendant admitted that he did not see Bloodworth actually shoot the victim, but he saw Bloodworth pull out a gun and raise it immediately before the defendant heard shots. The defendant further testified that he was merely an innocent bystander trying to leave the scene in order to go to get dinner when the homicide occurred. Thereafter, the jury convicted the defendant of manslaughter of first degree with a firearm, carrying a pistol without a permit, and the trial court sentenced him to 45 years imprisonment on the first count, concurrent to 3 years in terms of imprisonment for the second, for a total effective sentence of 35 years. Additional facts will be set forth necessary. Well, he got more than 35, so what am I missing? Okay. The defendant's first claim on appeal is that he violated federal court constitutional right to remain silent following the receipt of Miranda warnings by making repeated reference to his invocation of the right during the testimony trial. Hey, I got to tell you, from what we've seen, he could have totally been innocent. This is not, there's no, like, what is it? It's literally they pinned two dealers against each other. And that's it. That's your proof. So, hey, man, I'm not willing to say that he's not innocent, because they had nothing. Like, the idea that he lied to them, while being questioned, that's nothing. That, in my opinion, that doesn't stand for anything. That his alibi wasn't good. That doesn't. That a couple people said that he had a gun. I mean, okay, that's not It's all I mean, there are two dealers there, and one ratted on the other. That's all you have, in my opinion. The defendants first claimed that the trial court violated Doyle, improperly permitting the state to present evidence that he had terminated. And the idea that he's so stubbornly still fighting for his innocence, I mean, the problem is that just filing habeas corpus against every single one of his attorneys and having all these write-ups and being completely, all that works against him. But man, I have no problem believing that he could actually be innocent. Why not? How does a jury? It makes me wonder how juries can find people guilty beyond a reasonable doubt. Well, there is plenty of reasonable doubt in this case, if you ask me. I mean, what proof do you actually have at all? The defendant's next claim stated that he violated is referred to the defendant's most random. So we know that that's not going to pass. Subject completed blows of it. Okay. Likewise, a challenge colloquy in the present case was a prior inconsistent statement voluntarily made by the defendant at the police during December 9, 1999 interview. The police and the defendant stated that he could not confirm or deny a report of shooting in the neighborhood because he was not in the area. Essentially, he knew nothing about the shooting. At trial, however, the defendant changed his testimony on this subject and implicated Bloodsworth to the shooting death of the victim. Accordingly, pursuant to Anderson, the state properly could question the defendant on this point for the limited purpose of eliciting an explanation for his prior consistent statement. The defendant's final claim under Doyle is that the state's attorney referenced during closing argument that the defendant's failure to mention Bloodworth before trial were improper. Specifically, the defendant challenged the following statement. So the closing argument of the state's attorney said he never mentioned Bloodworth. He never mentioned him once. So, and you don't think, ladies and gentlemen, that if the defendant really was telling you the truth, that back on December 9th, 1999, when confronted with the accusation that hey, we're investigating the murder of somebody, where were you? And you give a phony alibi and you come back and say, hey, that's not the truth, but you're going to take the weight for somebody. Why didn't he tell the police at that point in time that Bobby Bloodworth was the guy who did the shooting, not me? Why didn't he tell when he was arrested on December 13, 1999, that Bobby Bloodworth did the shooting? Don't lay it on me. Doesn't it offend your common sense to suggest that he has waited all this time? And I would say, no, it really doesn't. It's it's easy for me to believe that if you had offered him the idea to pin it on someone else, that maybe he would have taken it. And you didn't. I mean, there could be so many reasons why he wouldn't have wanted to rat on his friend. Defense counsel, I'm going to object to that, Your Honor. This is absolutely improper about when he made disclosures to other people that are not part of this case. The court sustained, disregard that argument. It has no weight or application in this case. State's attorney, the defendant, told you that after December 9th and December 13th, he never told police officers in connection with the case that Bobby Bloodworth was involved. The defendant contends that these comments deprived him of a fair trial, and then we disagree. Okay, so they'll probably say because they... Yeah, because right here, moreover, we note that the trial court sustained the objection to the comment and immediately instructed the jury to disregard them. You know, I mean, all I gotta say is from what I'm seeing here, I don't imagine, I don't see why he couldn't be innocent. Frankly, I wouldn't, as a jury, want to find him guilty of something just because one of the guys said he did it. Wow. So I'm not going to go over all his other documents, but look, I guess there's two ways to look at this. One is that he's actually innocent and just pissed off for being wrongfully locked up, but that still doesn't, it's still not going to be an excuse. And whether you want to figure he's innocent or not, or just trust the system, I guess that's totally up to you. I don't know how you could say it's beyond a reasonable doubt having one eyewitness, a fellow dealer who has everything to lose and everything to gain by lying, is your only person to say that he pulled the trigger. But anyways, we're not here to try the case. We are here to see how he's done during all this time and 236 tickets, and then not seeming to understand why it's important for him to not get them. But so basically what it means is that in 3 years, he gets to have another bite at the apple. What he needs to do is stop getting tickets and try to get lower than to get his security rating lowered, and then maybe he can get a chance. But thank you, Richard, for the information. And with that, I'll let you go.